Lords, good morning. My Lords, along with Ms Sharma, I appear on behalf of the appellant, Notting Hill Genesis. For the respondent, URE Energy, we have Mr Sims, King's Counsel, leading Mr Wibberley and also Mr Puller for the purposes of this appeal.
Very good.
My Lords, just before I go into my introduction, there are two minor points of housekeeping. One is that, subject to your Lordship's approval, Mr Sims and I agreed provisionally a timetable. This is a day-and-a-half hearing, and we sent in a draft proposed timetable to your Lordships. I don't know whether your Lordships have had a chance to see that.
Yes, we've seen that, that's fine, although we may need to rise a little earlier than 4:30 this afternoon, but broadly speaking, that's
very good. Thank you, Lord. And then the other point of housekeeping is that there is an additional authority which Mr Sims has wanted to introduce. It's the case of Permavent versus Making, a decision with which Lord Justice Zacaroli would be very familiar. We have no objection to that. I don't think it's made its way formally into the electronic bundle, but it has been submitted electronically elsewhere.
right.
But we have no objection to that, and my learned friend will take his course with that authority as he sees fit.
Yes, all right, well, as and when we get to it, perhaps I at any rate would like a hard copy.
Thank you, Lord. So, my Lords, this is the appeal of the order of Mrs Justice Diaz, dated the 18th of October 2024, by which she allowed URE's claim for termination payment under the energy supply contract with Notting Hill Genesis. And I'll call the parties as they appeared in the judgment, URE and NHG, for ease of reference. And the reasoning for that order was set out in her Ladyship's judgment dated the 14th of October 2024. Now, first and foremost, this appeal raises important questions relating to the doctrine of election. Specifically, the court will need to consider the requirement of knowledge on the part of the electing party, and in particular, of the right that it is electing to waive. That's the subject of ground one of the appeal. Secondly, the principle that a party may be taken to have affirmed a contract even where no actual election is made, and that's covered by ground two of the appeal. Now, on these 2 points, we submit that there is no hard and fast requirement for actual knowledge of the right, and that, as the authorities show, depending on the circumstances, knowledge of the right may be deemed or presumed. And specifically, in the case of a right of an express term of contract, the parties are taken to know those rights, which are expressly created by the very contract into which the parties entered. Then the other point we submit is that in any event, after a reasonable time, the law assumes that an election has been made, i.e. an informed decision has been made, because that is ultimately the pragmatic response of a doctrine which is based on certainty, fairness, and common sense. In addition to grounds 1 and 2, there's ground 3. That gives rise to an issue of contract construction, namely the correct interpretation of clause 10.5 of the contract. That is the provision pursuant to which the amount of the termination is to be calculated, assuming that is in fact payable. All 3 grounds, you will have seen, my Lords, are substantively opposed. In relation to ground 1, URE also argues that it should be rejected on procedural grounds, namely that it's an impermissible attack on the judge's finding of fact as to URE's knowledge, and secondly, that it's a new point not previously advanced below. Very briefly, as to the first point, we say that's a mischaracterization of the argument. We say that the judge's finding involved an error of law, in particular because she applied a test of subjective understanding of the right as opposed to knowledge. That in any event, it's a secondary finding based on the judge's primary findings of fact, in relation to which this court is in no worse position to determine than the trial judge, and in granting permission to appeal, my Lord Justice Males made clear that permission was not being granted in respect of primary findings. We say thereby allowing permission for challenges to the judge's secondary findings. Your Lordships will have the PTA order dated the 20th December 2024 in the core bundle at page 17. Now, as to the second point, that this is a new point, we say that this is not a new point at all. It was raised expressly on the pleadings, but in any event, if it is a new point, it's a pure point of law, which requires no new evidence and would have not required a different conduct of the trial had it been raised below. Now, as well as opposing all three grounds of the appeal, URE advances two additional grounds of its own to uphold the judge's order. Firstly, that in interpreting clause 10.2 of the contract, that was the term in the contract entitling URE to terminate at any time. URE says that the judge was wrong to interpret the words at any time as not excluding waiver by election. That argument is set out in URE's skeleton in paragraph 68 to 76, page 74 of the core bundle. The second additional ground advanced by URE is that the judge was wrong to find on the facts that URE's continued performance of the contract and its continued demanding of NHG's performance of the contract would have amounted to a clear communication of an election. That argument is set out in URE's skeleton at paragraph 77 at pages 76 to 77 of the core bundle. Now, just turning specifically to the grounds, my lords, those are in the core bundle at pages 15 and 16. Ground one relates to the critical finding made by the judge that URE lacked sufficient knowledge to elect to waive its right to terminate the contract as set out in clause 10.2d, following the amalgamation of Genesis with Notting Hill to form NHG. Now, the finding in particular is in the judgment at paragraph 100, which is in the core bundle at page 164.
Yes.
And the finding specifically is the last three lines of paragraph 100. But the reasoning is also set out in paragraph 119 on page 173 and on paragraph 126 on page 170. Now, that critical finding that URE, through its director, Mr. Ensor, did not have sufficient knowledge to elect to waive its rights, was based on a primary finding that Mr. Ensor did not understand clause 10.2d, notwithstanding that it was an express term set out in the contract to which he agreed. That finding of lack of understanding is first and foremost in paragraph 103 of the judgment. On page 165 of the core bundle. Now, we respectfully submit that the judge's reasoning in this regard was flawed for a number of reasons. Firstly, the judge failed correctly to apply the established principles for the assessment of knowledge for the purposes of election. And that was because in reality, the judge introduced a test not of knowledge, but rather of understanding the legal right and its consequences, a test which we say is unsupported by the relevant authorities. We also say that her conclusion is at odds with the fundamental principle of contractual certainty, that a party who assents to an express written contract is taken to know of its terms and to be subject to them, even if it has not understood or even read them. And that's the principle which we say is set out and supported in the decision of Lestrange and Graukop. Now, ground 1 is broken down into 3 parts. Ground 1A, we say the judge wrongly concluded that URE should not be taken to know of the express terms of the contract. That finding in particular is in the judgment at paragraph 128, which is on page 178 of the core bundle. It is the last 4 or 5 lines of paragraph 128 in the top quarter of page 178. Ground 1B is that having found that URE was aware of the express termination provisions of clause 10.2d of the contract, the judge wrongly went on to hold that it was necessary for URE to understand it. And as we've seen, that's in the judgment of paragraph 101. And then finally, ground 1C is that the judge erred in finding that URE did not have obviously available knowledge because it did not understand the termination provisions and so did not suspect that it had a right of termination following the amalgamation. So those are the 3 subparts of ground 1. Ground 2, again, just going back to core bundle, page 15. Rather 16 it is. Ground 2. Ground 2 is that the judge erred in finding that there had been no deemed waiver of the termination right by URE despite the continued performance of the contract. And in relation to that ground, we rely upon the principle that there can be a deemed waiver by a fluxion of time, even if there is no informed election. And then ground 3, sorry, I should, before I leave ground 2, just to flag up, the relevant finding for the purposes of ground 2 is paragraph 143 in the judgment, which your lordships will have at page 185. There, the learned judge held that there had simply been a mere lapse of time, to use her phrase, and therefore that could not have amounted to an election on the facts. Ground 3 is that the judge wrongly held that clause 10.5 of the contract, which referred to the value of the contract to the supplier, provided for a termination payment based on turnover as opposed to profit. Clause 10.5 appears in the core bundle.
Sorry, I'm so sorry. Just on that last point,
Yes.
on paragraph 143,
Yes.
the judge seems to be making 2 points. One about the mere lapse of time, but also about the meaning of clause 13.1. And as I understand her judgment, she's saying that the clause 13.1 says that a mere lapse of time shall not amount to a waiver.
Yes.
And she then says, and this argument is based on a mere lapse of time. So in other words, this seems to be a point based partly on clause 13.1. Is that something that you've challenged?
Well, we don't challenge her finding in relation to her interpretation of clause 13.1. It was URE's argument, certainly at summary judgment stage, that clause 13.1, which is a no waiver by delay provision, standard provision, that applied because there could not have been a waiver because of just a fluxion of time. And the judge held that didn't apply in the context of this case because clause 13.1 is not apt to exclude an affirmation. Either there has been an affirmation to approve the contract, continue the contract, or there hasn't. But the affirmation requires something positive, a positive act, which is why she refers in paragraph 143 to a mere lapse of time absent some further positive act. So our case was and is that there was a positive act in continuing to perform the contract, something which the judge found, and that therefore she was wrong to characterise that as a mere lapse of time, which could be covered by clause 13.1.
So your ground 2 is not simply about a fluxion of time. Is that right?
Our ground 2 is that there's a deemed waiver because fluxion of time, but according to the principles set out in authorities, there must be an effluxion of time coupled with a positive act, and that the judge found that there was that positive conduct, which, subject to the issue of knowledge, would have given rise to an unequivocal communication, but that when we come to the issue of effluxion of time, the judge merely describes it as a mere lapse of time.
So your real complaint with her conclusion, it was a mere lapse of time.
Yes.
As a matter of fact.
Well, we say that with respect that the judge's reasoning is internally inconsistent because, having said the purposes of an election, well, there was conduct by URE which was sufficiently positive and unequivocal that it would have amounted to a communication of an election. But having found that, the judge was wrong to merely categorise the ongoing continuation of the contract as a mere lapse of time.
Yeah. Which paragraph is the inconsistent finding in?
It is paragraph 140. That's the summary. I was going to take your lordships to underground 3 to clause 10.5, just to finish my introductory submissions. So clause 10.5 is in the core bundle at page 318. Now, the point here, my lords, is that we say that on proper construction, clause 10.5, when referring to a termination payment for 50% of the remaining value of this contract to the supplier, that properly construed, that is a reference to the profit which the supplier would have made over the remainder of the contract. The learned judge disagreed with that argument below. She did so specifically in paragraph 184 of her judgment, which is in the core bundle at page 203. And obviously I'll be coming back to that. I will be taking the grounds in order as they appear in our grounds of appeal. But before I make submissions specifically on the grounds, I'm going to make submissions in relation to the authorities, not least because in doing so I think that will clear away, I hope, but submit some of the issues that arise in relation to grounds 1 and 2.
Yes.
So the issue before your lordship relates to the doctrine of waiver by election. That doctrine of election can be summarised as follows. It applies where a party is entitled to alternative but inconsistent rights or courses of action, and when that party has sufficient knowledge of the relevant matters, and I'll come back to that, presenting the choice of the alternative rights, and acts in such a way as to clearly communicate that it has elected to rely on one and forsake the other, then in those circumstances the party has irrevocably taken to have made an election between its rights. Now, the statement of the elements of the doctrine have been made with the highest authority. They've been made, for example, by Lord Diplock in Camen's Ballrooms and Zenith Investments, and in particular at page 883 of that judgment. Your Lordships will have that in the authority bundle at page 251. It's tab 10 in hard copy. And the principle is set out by Lord Diplock in that case at page 883, A and A to B. Talking of the doctrine of election, he held this arises in a situation where a person is entitled to alternative rights inconsistent with one another. If he has knowledge of the facts which give rise in law to these alternative rights and acts in a manner which is consistent with any of his having chosen to rely on one of them, the law holds him to his choice, even though he was unaware that this would be the legal consequences of what he did. He's sometimes said to have waived the alternative right, as for instance a right to forfeit a lease or rescind a contract of sale for wrongful repudiation or breach of condition. Now, your Lordships will have seen there Lord Diplock was referring to knowledge of the fact, and that obviously is an issue which resurfaces in the authorities which I'm going to take your Lordships to. But before doing that, another statement of the principle was set out by Lord Gough in the Kachinjunga, Motor Oil Hellas versus Shipping Corporation of India, and in particular the passage of his judgment is at pages 372 to 374 of the authorities bundle. It's tab 15 in hard copy. And at the bottom of page 397 of the report, that's page 372 of the bundle, then on the right-hand side column, right at the bottom, Lord Gough starts his discussion of the principles. And then over the page, at the top of page 398, third line down, he held this: election itself is a concept which may be relevant in more than one context. In the present case, we're concerned with an election which may arise in the context of a binding contract, where a state of affairs comes into existence in which one party becomes entitled, either under the terms of the contract or by the general law, to exercise a right. He has to decide whether or not to do so. His decision being a matter of choice for him is called in law an election. And then he goes on to give some characteristic examples of the application of the doctrine. And then if your Lordships look down just over halfway down on the left-hand side column, on the right-hand side of the column there's a sentence beginning, in all the cases. In all cases.
Yes.
He went on to say this: in all cases, he has in the end to make his election, not as a matter of obligation, but in the sense that if he does not do so, time may come when the law takes the decision out of his hands, either by holding him to have elected not to exercise the right which has become available to him, or sometimes by holding him to have elected to exercise it. We say that that final point is of particular relevance to ground 2. Because it talks in terms of essentially the law stepping in to deem an election to have been made even when a decision has not been. Before looking at some of the more pertinent authorities to the issues before your Lordships, I think it is helpful to just consider what the basis of the doctrine of election. Waiver by election is a principle which is based, according to the authorities, on mutual fairness, common sense, and equity, to be assessed against the established principles of contract law. That basis, or that foundation for the doctrine, was set out by Lord Wilberforce in Johnson and Agnew. Your Lordships have that in the authorities bundle at page 301. And it's page 398 of the report on Johnson and Agnew, and it's sections E to G. And those dicta were expressly approved and adopted in Oliver Ashworth versus Ballard Kent, a 2000 case, where and were cited by Lord Justice Walker. And your Lordships have that in the bundle, authorities bundle at page 553. And it's page 27 of this report at D to E. And then finally, I want to take your Lordships to the case of Cosmar Villa versus Trustees of Syndicate 1243. An authority will come to at various stages. But in particular, I want to throw your Lordships at this stage to paragraph 38 of the judgment of Lord Justice Ricks, which your Lordships have at page 677 of the bundle. Right at the bottom, page 677, paragraph 38. And that paragraph, I submit, is a useful summary in any event of the principles of the doctrine. But in relation to the foundation of the principle, Lord Justice Ricks talks about the conditions for the application of the doctrine, which make the doctrine mutually fair. And that it typically arises where the parties to a contract have to know where they stand. So, on the basis of those statements of the principles of doctrine, we submit that election is a concept which is rooted in common sense and fairness, designed to hold parties to fair dealings with each other, so that neither is subject to inconsistent or capricious changes in the position of the other. It is therefore a doctrine which has been developed to uphold contractual certainty, and that's why once an election has been made, it is irrevocable. Now, of course, it is trite that in commercial transactions, certainty is of the utmost importance. That's a principle that's been emphasised on countless occasions by the courts, and most recently by the Privy Council in the Golden Victory, which is at page 1240. Of the authorities fund. It's the judgments of Lord Hamlin and Lord Burrows, paragraph paragraph 47.
Do you have a tab number? Sorry.
Oh, I'm sorry, my lord.
That's all right.
It's tab 40.
Thank you.
Yes. Which paragraph was it, please?
It's paragraph 47, my lord. Under the heading in italics, the importance of certainty in commercial contracts. And it, Lord Hamlin Burroughs cites there the dicta of Lord Bingham in Golden Strait versus Nippon Yusu. So it is, of course, a trite proposition, but in the context of this case, I submit it is something which must be underlined, that when one's looking at the application of the doctrine of election, it's one's having to think about common sense outcomes and certainty within that broad principle, certainty between dealings between the parties, which is of the utmost importance.
Yes, Lord Bingham was in fact in a dissenting judgment in a case where Mr. Hamlin was unsuccessful counsel, but it looks as though between them they had the last word.
Well, yes, it looks like there was some compromise broke out there. So that's the basis for the doctrine of election. I want now to turn to certain elements of the doctrine. First and foremost, the requirement of knowledge. Now, it's an established principle for there to be a waiver by election. The electing party must have sufficient knowledge of the relevant matters which present the choice between the two alternative and conflicting courses of action or rights. And there is a line of authority which recognises the proposition that the relevant matters of which knowledge is required include not only the facts giving rise to the inconsistent rights, though I'm just pausing there, those were the facts which Lords Diplock and Gough in their judgments we've looked at were focusing on knowledge of the facts. But also...
Well, Lord Gough expressly put to one side
he did.
Knowledge of the right was necessary.
He did. He said, express it in parentheses, that he was not dealing with that because in that case knowledge was accepted. But nonetheless, those authorities have been referred to previous decisions as focusing on knowledge of the facts alone. But there are, of course, authorities which establish that knowledge of the legal rights themselves is required in order for there to be an informed choice to give the basis of an election. Now, one of those authorities is the case of Teddy 2 International Card versus Post Office. And your lordships have that in the authorities bundle behind tab 24, and the relevant part of Lord Justice Aitken's judgment is on page 707.
Do you know which volume of the authorities that's in?
Well, I'm terribly sorry. I haven't done my cross-referencing by hard copy bundle file numbers.
Volume 2, thank you, I've got it.
So it's paragraph 53 of Lord Justice Aitken's judgment, and there he summarises the principles of the doctrine of affirmation, as he calls it. I'm just pausing there. There are references to affirmation election. We say there's no distinction between those terms for present purposes. And in 6 lines down, the second element which he refers to is a prerequisite to the exercise of election that a party is concerned is aware of the facts giving rise to its right and the right itself. And as my Lord Justice Males has already commented, this summary given by Lord Justice Aikins is not entirely accurate because, of course, he's referring to the principles set out by Lord Gough in the Kanchenjunga, where Lord Gough didn't talk about knowledge of the rights, but Lord Justice Aikins is there saying that is a requirement.
Although this is one of the cases where it wouldn't matter because paragraph 49,
Knowledge was
there was knowledge of both.
well, yes, and we say, well, of course, because in that case there was an express termination right in the contract. So that would explain, we say, why no point was taken. Now, the lead authority for the principle that there is a prerequisite for waiver by election is that the party must know of the facts and the right itself is the Court of Appeal decision in Payman Lanjani, and your lordships have that behind tab 14, and I apologise, I'm not quite sure which folder that appears in yet, but it's behind tab 14. And it's the interpretation of the judgments and the ratio in that case, which to a large extent lies at the heart of this appeal. I won't trouble your lordships with a rehearsal of the facts because time doesn't allow, but it was quite an unusual case of involving Iranian gentlemen who did not speak English, impersonations in relation to gaining consent or subleases, and the most egregious conflict of interest on the part of the second defendant, who was solicitor acting for plaintiff and the first defendant. All of that really, for the moment, is by the by. The key point in terms of the facts really was that there was an irremovable, a latent defect, an irremovable defect in the title of the first defendant in selling the property, and it was said that the plaintiff was on notice of that irremovable defect because he had known that it had been acquired by impersonation, but nonetheless proceeded to complete the sale contract. The outcome of the case was that, as your lordships will have seen, was that the Court of Appeal decided that there had been no election to affirm the sale contract in circumstances where Mr. Payman was not aware of his legal right to rescind because of a defect in title. Now, in arriving at that conclusion, the Court of Appeal, in particular Lord Justice Stevenson, sought to resolve a long-standing dispute on the authorities, or debate on the authorities, because there had been two different lines of authority, one in which knowledge of facts was deemed, only the facts was deemed to be sufficient. And those were authorities such as Clough and Liverpool North West Railway, Scarf and Jardine Camins, and another case called Matthews and Smallwood, which I'll come to in a moment. And there was another line of authority which, for the proposition that there needed to be knowledge of the legal right. And in particular, the Court of Appeal referred to the decision of the House of Lords in Young and Bristol Aeroplane, which was involved a claim for compensation under the Workmen's Compensation Act, which created a statutory option. And another case of the decision of the House of Lords in Evans and Bartlam, which involved potential waiver of a right to set aside a default judgment when a stay had been sought to comply with the judgment. Now, in the last two cases, the House of Lords referred to there being a requirement for knowledge of the right before there could be a waiver. Now, in giving the lead judgment on this issue, Lord Justice Stevenson favoured the line of authority supporting the knowledge of the right requirement. And his reasoning, in particular, is set out in pages 486 to 487 of the report. The lordships will have that at pages 348 to 349 of the authorities bundle. So halfway down the page, on page 486 of the report, at F, this is after referring to Lord Diplock's dicta in Cammins. Lord Justice Stevenson sets out various factors which she says explains the differences between the House of Lords line of authority, and to justify why he favours the Young, Bristol Aeroplane and Evans and Bartlam line of authority. For example, he says that the dicta of Lord Diplock, which refers to just the facts, were obiter dicta in that case, which was obviously strictly correct. And also he referred to the fact that the other House of Lords authorities, Young, Bristol Aeroplane, and Evans and Bartlam, were not cited to the House of Lords in Cammins. So that his reasoning there is set out. We don't need to go in too much detail through all of those paragraphs, but I want to pick up on a particular part of his reasoning on page 487, and it's at section C, and it's 2 lines just above the C on the left-hand side, where Lord Justice Stevenson held as follows: election leads, I think, to waver, whether in choosing to object or not to object to breaches of contract or in acting in accordance with rules of procedure or statutory provisions. So pausing there, he's saying that election can apply irrespective really of how the right arises, contract, statute or procedure. And then he says this: but common sense prevents landlords from saying that when they demanded rent from a tenant in breach of covenant, they did not know they had a right to retake possession, which they were waiving. And he cites a case of David Blackstone Burnett. And he says the Sale of Goods Act 1979 prevents buyers from saying that when they accepted goods from a seller in breach of the condition, they did not know that they had a right to reject goods which they were waiving. And then he goes on to talk about a presumption of knowledge where a party has legal advice. Now, it's clear from that brief passage in the judgment, in my submission, that while Lord Justice Stevenson regarded the general rule to be that knowledge of the right was required, as well as the facts giving rise to it, he also regarded he also considered that knowledge of the right can be established in different ways depending on the circumstances of each case, and that there may be possible exceptions to the requirement. In relation to statutory rights, he held that there may be cases where the statute restricts a party's choice between alternative courses. That's the reference to the Sale of Goods Act point in that passage. And he'd already referred to that earlier in his judgment on page 483 at D to F, which your lordships have at page 345 of the appeals bundle. So there he refers, at D, he refers to the Sale of Goods Act essentially taking away the element of knowledge for the purposes of election under the Sale of Goods Act.
What's the internal page of the judgment?
Oh, I'm sorry, it's 483, my lord.
483.
D to F. And then at E to F, he contrasts that with the option that the House of Lords were dealing with in younger Bristol Aeroplane, which was a statutory option which did not remove knowledge in the same way. Now, so that's the first, what I would say would be an exception to there being a hard, fast rule of subjective knowledge of the right, which was expressly acknowledged by Lord Justice Stevenson in this part of his judgment.
He refers to 2 things there. One is statute, which is the Sale of Goods Act.
Yes.
And the other thing is he says common sense prevents landlords. Now, is he saying the law prevents landlords? Is he saying that's a legal principle? Or is he just saying a common sense view of the facts is likely to mean that a landlord can't say he doesn't know about the right to re-enter? And it's interesting that he uses that phrase, common sense.
Well, my Lord, yes. My Lord, I say it's no accident, because we're dealing with the principle of election, which is based on, as we've seen, principles of common sense. Common sense is a principle, and he's not saying there specifically that as a matter of fact, just looking at the facts is common sense. He's, in my submission, he's saying when one applies the doctrine of election as a matter of law, one has to apply a common sense test. And your Lordship's question anticipates the point, next part of the judgment I was going to come on to, which explains that. Because earlier in the judgment, having dealt with, we can move on from statutes, but having earlier in the judgment, Lord Justice Stevenson dealt with the same common sense scenario to which he was alluding to on page 4887, namely whether a landlord could be deemed to have elected to have waived a right of forfeiture by continuing to accept rent. And he does that at the bottom of page 482. At G to H, because he refers there to the case of Matthews and Smallwood, which I mentioned in passing earlier. Now that was a case where there was a right of re-entry under the lease, which had been triggered, but the landlord continued to accept rent. And in that decision, Mr. Justice Parker referred to an election on the part of the landlord arising because he had knowledge of the facts. And so, in the debate before the Court of Appeal in Paymalanjani, Matthews and Smallwood was relied upon for the proposition that only knowledge of the facts was required. Lord Justice Stevenson explains the ratio of Matthews and Smallwood because, as turning on the fact, because it involves a landlord and tenant, where there was an express right of re-entry. And so there was no need to refer to knowledge of the right. Only knowledge of the facts was relevant. And we see that in particular from what he says in his explanation at 482H. He said this: the necessary knowledge, actual or imputed, have not been proved, nor have the necessary action. No inference in favour of the second alternative, that knowledge of the right was necessary, can be made from the judge's references to knowledge of the breach, because there was, and perhaps could be, no question that the lessor, and perhaps every lessor, must know or be taken to know of the right of re-entry given him by the express terms of his lease. So we submit there that the point that Lord Justice Stevenson was making there is that where a party has an express term given to it in its contract, then it's taken to know what that right is.
It looks as if Lord Justice Stevenson may well be saying that this is a rule of law, because he refers to the David Blackstone case, which we have at tab 11 of the authorities.
Yes.
And at page 268 of the bundle, 1501 of the law report, Mr. Justice Swanwick says once he or his agent, that's once the landlord or his agent knows the facts, an appropriate act will in law effect a waiver or a forfeiture. His knowledge or ignorance of the law is, in my judgment, irrelevant. He goes on to say that there'd be all sorts of problems if that were not so. So that seems to be what Lord Justice Stevenson is referring to. He doesn't say which part of the judgment he's talking to, but it looks to me as if that's probably it.
Yes, but the references, taken together, the references and the explanation of Matthews and Smallwood, and taken with the reference to common sense outcome in Blackstone and Burnett, in my submission, set out a legal principle that where there is an express right in a contract, be that a lease or any commercial contract, that the party who has given an express right according to the terms of that contract is taken to know it.
Is it possible that there are two meanings to the idea of not being aware of their legal rights, or whatever it may be, or in ignorance of their legal rights? One is knowing of the legal right to make the election. In other words, that they, sorry, I'll start that again. Knowing of their right to terminate. That's one sort of possible ignorance of the law. The other possible ignorance of the law is that the person doesn't understand, as it were, the doctrine of waiver, or not. So in other words, doesn't understand that by doing one thing or another, they may be giving up their rights. And that seems to be something that you find in Claimant, where Lord Diplock says that ignorance of the law is irrelevant. So is there, may there be two different sorts of ignorance of the law that arise here? One is ignorance of having the right at all. The second is ignorance of the fact that you may be waiving that right by doing something.
My Lord, yes. We say this feeds into, or this relates to the error that we respectfully say the judge fell into, because there is a distinction between knowledge of the right, the first knowledge that your Lordship refers to, and knowledge of the consequences of having the right, or of exercising the right, or of not exercising the right. And now knowledge of those consequences is not a requirement of the principle of the doctrine of election. That's clear from what Lord Diplock says in Canons, but also Lord Justice Stevenson agrees with that in his judgment, explaining the dicta of Lord Diplock in Canons. For example, again, it's at page 486, I think. Yes. So, in interpreting the dicta of Lord Diplock in Canons, Lord Justice Stevenson says, and this is in the bundle at page 348, tab 14, page 348, internal page 486.
Yes.
So there he talks about that Lord Diplock was considering the elector's ignorance not of his legal rights resulting from the fact, but of the legal effect resulting from his exercise of that right. And it's never been the law that the elector must know also that if he chooses one way, the law may judge his choice irrevocable. So it's no answer for the waiving party. We submit. We say it's no answer for the waiving party to say, well, I knew I had a right, but I didn't know what consequences would flow from that if I were to continue with the contract. Lord Justice Mayles helpfully referred to the decision in Blackstone Burnett. Of course, in that case, there were certain features which resonate with this case, because the landlord's clerk. Just to recap, your Lordships may recall that was another landlord and tenant case where consent had been given to grant a sublease to two individuals. And in fact, the sublease had been granted to the company with which the two individuals were connected, the director and secretary. And a demand for rent was issued following the grant of the sublease, and it was held that that amounted to a waiver. But in that case, the demand for the rent was sent by the landlord's clerk in another office, just as a matter of course, without any knowledge that there had been a breach entitling the not certain that there was in fact a right to terminate the lease in circumstances where the sublease had been granted to a company as opposed to the two individuals. And we see that in internal page 1500, so over the page, and that's at sections G to H. So not only was the person who committed the act which gave rise to election being made ignorant of the right, but also the person whose knowledge was attributable to the company for these purposes did not fully understand the rights that the landlord had, and yet still it was found that there had been an election. And the reason why is because there was an express term, and we see that in particular over the page 1501 internal at E and F with the judgment of Mr. Justice Swanwick.
So just to understand this case, the judge doesn't actually make a finding that Mr. Fraser didn't know the right. What he says is that, well, he says he didn't know, but it's irrelevant because he doesn't need to have it.
Yes, exactly. But we say it resonates because what Mr. Fraser was saying was, he said, well, I wasn't sure, I wasn't certain.
Yes.
And he was a solicitor.
But the ratio of Blackstone is that there is no need to show knowledge of the legal right. That can't sit, can it, with Payman and Lanjani?
Well, my lord, we say it does sit with Payman and Lanjani, not least because Lord Justice Stevenson says it's common sense.
Well, what he says is common sense. He doesn't dispense with the requirement that you need to have knowledge. He just says in certain cases it can be presumed.
Yes, but he says in relation to Matthews and Smallwood that where a party has an express right conferred by its contract, it's taken to know that right.
Yes, it's a different way out of the conundrum. It's not saying you don't need to show knowledge. It's just that in certain cases there is deemed knowledge.
Yes, exactly. On this appeal, we do not seek to overturn the overriding principle in Payment Langiani, which is that you don't need to have knowledge of the right. We say that Payment Langiani can be explained and reconciled with other decisions because it doesn't lay down a hard and fast principle or requirement of knowledge of the right. It says that's the general rule, but in some circumstances it can be deemed or assumed or taken. Deemed under the State of Goods Act, and where there's an express right, a party is taken to know, I assume to know. But your Lordship is right, the requirement for knowledge of the right is still there.
And you say it's deemed to know, not presumed to know, subject to a rebuttal.
Yes, we say where you've got an express right in the contract, you're deemed to know because you've expressly agreed to a contract which expressly creates the rights which give rise to the election. And that deemed knowledge, we say, is a pragmatic and common sense outcome, which is though that is the approach which is at the root of principle of waiver by election. Now, a point we've made in our skeleton is that when one looks at the judgments in Payment Langiani, you can see that the Court of Appeal gained a great deal of assistance from an Australian decision, the Supreme Court of Victoria decision in Coastal Estates and Malvendi. For example, on page 408, going back to Payment Langiani, tab 14, at page 348 in the authorities bundle, this is 486 internal F. Lord Justice Stevenson said he found Coastal Estates Malvendi very helpful, particularly helpful. And the approval of that judgment was unqualified. There's no attempt to depart from it in any way or to explain it at all. And we say that that is illuminating when one actually looks at what was decided in Coastal Estates and Malvendi. And your Lordships have that in your authority bundle behind tab 41. That should be in volume 3. Now, Coastal Estates and Malvendi was another property sale case involving fraudulent misrepresentation and an alleged waiver of that deceit. In this case, as a general proposition, all three of the judges recognise a principle that for election there must be knowledge of the right before you can elect. But a distinction was drawn by Chief Justice Herring between common law rights, which that case was specifically dealing with, the common law right to rescind, and express contractual rights. And he held that there may be cases where it's proper to assume that a party to a contract who has an express right to terminate knows that he has such a right, or that knowledge of that right is to be attributed. And the reasoning is set out.
Does that mean that what's said on that subject is obiter? That's what's said on the latter subject is obiter?
Strictly speaking, my lord, the case did not concern express contractual rights.
Yeah.
So it wasn't a necessary part of his decision.
Right.
But nonetheless, he was trying to rationalise when knowledge of the right is necessary, and was drawing distinctions between other examples of when the application of the doctrine could arise. And he drew the distinction between common law rights and express terms of a contract. This is on page 1254 of the authorities bundle, and it's the fourth full paragraph down, beginning, "Now it may be." If I could invite your lordships to look at that. And that was a distinction which another judge in this case agreed with, His Honour Judge Adam. And we see that at page, in the bundle 1269. And it's the final paragraph on that page. Now,
does he? In this paragraph, isn't he talking about something akin to estoppel there?
well, my lord, he says it may be that it could be explained by estoppel, but he offers other alternatives. He says, or the rule against approbating, reprobating, or perhaps more broadly on general considerations of justice. So he's not pinning his colours to any particular mast in terms of how it can be explained. But I think fundamentally what he's saying there is that in the case of a contract with an express right, there is an election because actions which are taken as if the rights, as if the contract was subsisting, is adverse to the counterparty. And that's not adverse in a traditional estoppel sense, one of detriment. It's adverse in the sense that it's demanding performance of the counterparty, for example, payment, and causing the other party to believe that the contract is subsisting. We can see that in the following paragraph, which is the second paragraph on page 1270. Because there he's talking about the adverse conduct amounting to the communication, the unequivocal communication of the election. And whilst Judge Adam here is saying, well, it's something akin to an estoppel, he doesn't go that far, and in fact, he can't be, because when one looks at the principle of estoppel, knowledge of the waiving party is irrelevant. It's what the counterparty does or suffers, not what the electing or waiving party knows. And here he's talking about what knowledge, element of knowledge is required, part of the waiving party. So, so yes, he offers up some possible explanations as to how it all works as a matter of principle, but in the end he simply says, well, it could just be overall justice, but the explanation for why that works is because there is unequivocal conduct on the part of the waiving party, which is not simply sitting on its hands as if silently, as if the contract is continuing, i.e. a mere lapse of time. It is positively acting in a way which is adverse to the counterparty.
Is what he's talking about something based on justice or equity which has nothing to do with election, but on a forfeiture of the right to act? Is this the category we're in? Because they're looking at the words of the 6-7 lines from the end of the second paragraph on page 1270. Because on principle, he treats it as free to avoid such a contract until such time as he may have actually elected to affirm it, but I think he means in acknowledge for.
Yes.
Unless upon some other recognisable ground based on justice or equity, but which has nothing to do with election as such, he has forfeited his right to elect. So that's the exception he's talking about.
Yes, but he that in the previous paragraph he still says that if a party unequivocally acts as if inconsistently with his express contractual rights, then a waiver will be will arise. So. And this discussion here in the judgment, in my submission, is dealing with evaluating different types of unequivocal conduct. So that if you have unequivocal conduct and an express right, well then the party is deemed to has elected. But where the conduct is not so unequivocal, then one has to look at other principles in equity and fairness. Now we'll come on to another Australian decision of the High Court of Australia shortly. That's the case of Sargent, which approves this distinction between contractual rights and common law rights. But before I do that, I just want to finish on some points relating to payment. Firstly, just to reiterate that payment concerned not an express contractual right, but a common law right to rescind. And
have you finished the references in payment to this Australian case?
Yes.
Because there is the only passage which Lord Justice Stevenson, but actually Lord Justice May, I think, who cites a passage from the decision, and that's from the judgment of Mr. Justice Scholl, page 495 of the report, where it looks as if Lord Justice Scholl is equating this action adverse to the opposite party as akin to estoppel, like
Yeah.
something giving rise to detriment.
Yes.
And
So
that's the only part that I think is a cited actually in the case.
I think that's right, my Lord. Yes.
Yeah.
Yes. But before I get on to Lord Justice May, I was just reiterating that in payment, we were dealing with a common law right, not an express contractual right. And then the judgment of Lord Justice May, he entirely agrees with what Lord Justice Stevenson says. He says that page 492 of the report. That's page 354 of the bundle. And then page 494E.
I don't think he does actually. He says he agrees on other points,
Yeah.
which he's not going to give a separate judgment on.
Lord, yes, you're correct. But in relation to coastal estates, he refers to that at 494 E to G. And in particular out of G, he says, I too have respectfully and gratefully obtained great help from the judgments of the Supreme Court of Victoria. And doesn't seek to draw any distinction between what Lord Justice Stevenson says in relation to express rights, for example, in a lease, and what was said by the Supreme Court of Victoria in coastal estates. And in fact, the main focus of Lord Justice May's judgment is dealing with the question of knowledge in relation to the type of right which arose in that case, namely a common law right. We see that, for example, at 494C, where he says, for the purposes of this judgment, I will confine myself to the case where a party to the contract becomes entitled either to rescind or to affirm as a result of some conduct on the part of the party. So he's expressly saying at A to B that whilst Lord Justice Stevenson has set out that rights can arise which could be waived in different circumstances, his judgment is focusing on common law rights. And the other specific point to raise in relation to payment is that on the facts of that case, the Court of Appeal found that in any event, whatever the rights and wrongs on the question of knowledge, there was no unequivocal affirmation. We see that from the judgment of Lord Justice Stevenson at page 491C. And then Lord Justice May at 496D. And Lord Justice Slade at 501E. So on the facts of that case, in any event, I think Lord Justice Slade says, well, whether, irrespective of the issue of knowledge, there's no unequivocal communication of an election. We say that the underlying ratio in this respect in payment is that while the Court of Appeal found that, that for a party to make a binding election, it has to have knowledge of the right that it is waiving, that was framed against the general rule in relation to which knowledge can at the same time be established or assumed or deemed, to use words that my Lord Justice Zacaroli adopted. But specifically in relation to rights that are expressly set out in a contract, it is authority for the proposition that a party is deemed to know of any right of election that is conferred by the express terms of its contract. And that is the an underlying ratio of Payment Lanjani has gained some academic support. For example, in
So I can see that you submit that Claimant Lanjani doesn't decide the contrary. I'm not sure why you say that it is ratio that you are deemed to know of your contractual rights.
well, it's authority for that proposition. Ultimately, because it didn't involve a case of an express contractual right, and there was no unequivocal communication. It didn't matter in that case. But
I mean, if it's ratio, what you said, then we're bound to follow that. End of case. But I don't think you really go that far, do you?
Well, no. But I submit it is very helpful authority to explain how the requirement of knowledge and how it is to be applied sensibly and fairly is to operate for the purposes of the doctrine of election.
Yes.
And there is some agreement for that, or academic support for that. In his article Exploring Election, Judge Handley says that is one of the underlying principles of Payment Lanjani. Your Lordships have that in the authorities bundle behind tab 59, which is volume 4, and that's at page 127, 1891. There's the author sets out the principles which underpin the relevant reasoning Payment Lanjani included. Parties deemed to know of any rights of election conferred by the express terms of its contract.
I'm sorry, I've got the wrong page. They were at page
1891.
Oh, 9.
I beg your pardon.
Yes, he says that Payment Lanjani was wrongly decided, which is not a luxury which we have.
No, it's fair to say he's critical of the decision of Payment Lanjani, but in this article in my submission he very helpfully sets out how it can be explained and interpreted in light of other authorities. one of those other authorities was decision of the High Court.
Just before you leave that case, sorry, I'm just trying to understand what actually was the right that was exercised in Claimant and Lanciani. Was it actually a contractual right?
My lord, no. It was a common law right.
But what does that mean?
It was not an express contractual right. It was a right at common law to rescind a sale contract for defect in title. I can take your lordship
Yes.
to where it's dealt with.
But is that an implied term of the contract, or is it something else?
My lord, it's explained by much better than I can explain. I think by Lord Justice Slade in Payman Lanciani at it's page 358 to 359 of the authorities bundle.
I mean, when they talk about rescission in this case, are they talking about a right to rescind like the right to rescind for misrepresentation? Or does it mean a contractual right to bring the contract to an end because the purchaser can say, well, you haven't given me good title, so I'm not going to carry on? In other words, rescission is often a slippery word, and I'm just wondering whether it's strictly a right like a right to rescind for misrepresentation, or whether it really means that the purchaser can say, I'm not going to complete and I'm going to treat the contract as at an end.
My lord, as I understand it, it is, if I can put it this way, a common law right as opposed to a contractual right, and a common law right akin to a right to rescind for, say, misrepresentation. It's referred to by Lord Justice Stevenson at page 482 of Payman Lanciani, page 344 of the bundle. And then, well, he there refers to the explanation provided by Lord Justice Slade, and your lordships have that at page 358 of the authorities bundle. That's an internal 496. And an H at the bottom, Lord Justice Slade there sets out what the right is, and he doesn't say it's an implied term. He refers to it as he refers to Horsfield's Laws of England.
Yes, and there it's before the contract, but then it goes on, he goes on to say, but it may be, as I understand it, that later on he may still be able to rescind if it's a latent defect, which seems to be saying that even where in other circumstances he's deemed to accept the title, if it's a latent defect, he still has the right to.
Yes. Yes, and a latent defect is a defect which is irremovable.
And then he does refer, in fairness, at E to it being voidable, which rather suggests it's something like misrepresentation, the
Yes.
right that arises on misrepresentation. Sorry, that's a diversion.
No, I mean, it's very helpful, my lord. I mean, one can see actually it's a sort of species of misrepresentation because the vendor is representing that it has good title, which is in circumstances where the purchaser has no way of knowing that is a correct misrepresentation. And so the right to rescind arises only once the knowledge of the latent defect is obtained.
Is the distinction you're drawing based on express contractual rights? So that if you have an express contractual right to terminate, you say there is deemed knowledge of what the contract says. But if it's a right which is given to you by the general law of contract, for example, to accept a repudiation, then that may be different.
Well, yes, and there's a good common sense reason why those two are to be distinguished, because with an express term in a contract, the party has already signalled its agreement, its intent to be bound by those express terms. It has expressly agreed to create a right of election under the terms of the contract. That is very different when compared with a situation whereby there might be a right at common law to which the party has not expressly given its assent. It is out in the ether, to put it that way, and therefore one can more readily explain a requirement to have knowledge of the right in those circumstances. So, with an express term in the contract, the right is already, if I can put it this way, priced in from the outset. Well, that distinction, I intend to leave. I intend to leave Payman Lanjani unless your lordships have any other questions.
I think it would be helpful to, you rely upon that article at page 1891.
Yes.
For the proposition that the case Lord Justice Stevenson stands for the proposition that a party is deemed to know of any right of election conferred by the express terms of his contract. Precisely which bits of Payman and Lanjani does that come from?
My Lord, I say that comes from his explanation of the judgment of Mr. Justice Parker and Matthews and Smallwood.
That's a bit at 482, is it?
Yes.
At the bottom.
Yes, that's right. 482 G2H.
Which is only talking about lessors.
Well, look, that on the fact of that case, yes, but I submit it goes more widely than that, because he's talking there more about knowledge of what the express terms provide, rather than it being a specific. And this, I know this is an argument I know a friend will develop. He says that there's a public policy exception for landlord and tenant. We say that there's no reason for that. That what Lord Justice Stevenson was talking about here, was focusing on, was that the knowledge of the party, in this case a landlord, of what was expressly set out in the lease, what rights were expressly given in the lease, and that principle should apply to other forms of contract.
So it's the words the lessor and perhaps every lessor must know or be taken to know. That's the basis of the proposition.
Yes.
So that's where you say he makes this proposition.
Yes. Yes. He enforces that, as it were, or emphasises that when he, in passing, refers to Burnett and Blackstone or the outcome of that as being common sense. And as we've seen there, the decision in that case turned on an express term, and the court held that lack of actual knowledge of that express term was not excusable. So, I'd like to turn to another Australian case, which which is the case of Sargent. This was a decision of the High Court of Australia. Your Lordships have that in volume 3 behind tab 42 at page 1273. And in the first judgment, the judgment of Judge Stephen, the distinction which Chief Justice Herring-Trew in Coastal Estates is endorsed at page 1276 of the bundle. Oh, sorry. No, it's 1278. It's a paragraph 25 and 26. Where he says that the distinction between express terms and other rights is well founded, but also explains some of the conflicting decisions in the authorities. And indeed, in paragraph 27, he says, well, the failure to draw the distinction between express contractual rights and other rights is really at the root of some of the confusion or conflicting decisions in other authorities. But the point he makes at paragraph 26 is, for the reason for the distinction, is the point that we wholeheartedly commend to your lordships, because the distinction can be justified by reference to principle in Lestrange and Graucop, as he held there, which effectively attributes knowledge of express terms to a contracting party, irrespective of whether they've read or understood them.
Is that what that case says?
My lord, it is a case on whether certain terms were incorporated into the contract, but the reasoning of that case in my submission is that the reason why clause was held to be incorporated was because there had been it was an express term to which the party had expressly signed up to, and therefore it had shown an intention to be bound by it.
On those cases where the court has said that if you sign a contract, you're stuck with its terms whether you know them or not, that seems to be different from the idea that you're deemed to know the terms. And in fact, the judge goes on to say, at all events, he cannot take advantage of his own ignorance, which is a different point. In other words, is that case anything to do with knowledge, or is it just a rule that says that if you sign a contract, if you don't bother to read it, you're stuck with its terms?
That's the principal decision in that case. But underlying that, it must be, in my submission, right that the party is stuck with those terms because they've agreed to them to be bound by. That they've signed up to that agreement. They have expressed an intent to be bound by those rights. And showing that intent, they must have a knowledge of those rights. Therefore, they are deemed to know them. It presents a conceptual problem that you are not deemed to know that which you intend.
Well, it may follow from the objective theory of contract law, but that doesn't depend on knowledge. In other words, you're objectively taken to have consented to whatever the terms are if you sign the piece of paper. But it doesn't follow that you actually know of the terms of the contract. And I think that's what that case establishes, and the other cases that are referred to in it.
Yes, but if I can take your lordship back to, well, we are dealing with the principle of election, which the touchstones of which are certainty, fairness of dealing, common sense. These authorities in my submission establish that where a party has signed up to an express contract with express rights of termination, it is deemed to know them because that is the common sense and pragmatic outcome where the parties need to know where they stand. So that is a justifiable example of there not needing to be actual knowledge in a subjective sense, but rather that knowledge can be, or parties taken to know them because they have already agreed to be bound by them. In the same way that in relation to sale of goods cases, it is different, but the principle, the wider principle is the same. As a matter of law, a party is deemed to know the right to rescind. There's no, as a matter of principle, there should be no surprise, therefore, that where a party has positively agreed to express terms of a contract, that it should be deemed to know them. There's another reference in the Sergeant as well, because in the other judgment of Judge Mason, that's at paragraphs 33 and 34. In the bundle of pages 1286 and 1287. And in 34 he says that the proposition that a party to a contract is deemed to know, express rights in the contract, is deemed to know them. And he goes on to talk about, or deals with the point that arose in the coastal states, which is the adverse acts amounting to unequivocal affirmation. There he's not talking about estoppel, he's talking about election. But also I want to then move on to what type of knowledge is required, because URE's position is that actual knowledge and only actual knowledge will suffice. And my first submission in response to that is that, well, we can see that that is not correct from the judgments in Payman Lanjani, where there are different cases where knowledge can be deemed. But also, we can see from other authorities that there's an extended definition of knowledge as being obviously available. That primarily is to be found in the decision of the judgment of Lord Justice Ricks in Cosmar Villa and Trustees of Syndicate 1243. Your Lordships have that in Volume 2, tab 23, page 689. There he refers to at H. It is only in the case of a stop order that the representee is entitled to rely on apparent promise or choice conveyed by the representation, irrespective of the actual knowledge of and decision of the party choice. However, there will be some circumstances where, even in the absence of an actual election, the party with the choice created by relevant knowledge, actual, obviously available, will be regarded as having been exercised after a reasonable time has passed. So that refers to an extended definition of knowledge, obviously available. There is long-standing authority for the proposition of there being knowledge which is not actual but could be obtained by obvious means. It goes back as far, for present purposes, to a decision in Oldcard and Skinner, which your lordships have in the authorities bundles behind tab 4, so that's volume 1, tab 4. And this just very briefly, this case involved a will which the plaintiff said had been procured by undue influence as she was taking orders into a sisterhood. And later, when she left the sisterhood, but much later, decided she wanted to terminate it, but after a considerable period of time it had passed. And it was held that it was too late and that she could not rescind the will for undue influence. The question of knowledge, that was dealt with in two parts of the judgment. Firstly, by Lord Justice Lindley, which is at page 124 of the bundle. That's page 188 internal, and it's the second paragraph. It was urged that the plaintiff did not know her rights. And then 5 lines down in that paragraph, in the next place, if the plaintiff did not know her rights, her ignorance was simply the result of her own resolution not to inquire into them. And then he goes into the facts on that reluctance to inquire into them, and then says further down, under these circumstances, it would, in my opinion, be wrong, contrary to sound principle, to give her relief on the ground that she did not that she did not know what her rights were. Ignorance, which is the result of deliberate choice, is no ground for equitable relief, nor is it an answer to an equitable defence based on laches and acquiescence. Again, it was urged that the defendant has not been prejudiced by the delay, and nothing has been done on the faith that the plaintiff did not require her money to be transferred to her, but I do not think this is material. And then over the page 189, 4 lines down. It's not, however, in my opinion, necessary to prove so much as this, whether the plaintiff's conduct amounts in point of law to acquiescence or laches, or whether it amounts to an election not to avoid avoidable transaction, or whether it amounts to a ratification or confirmation of her gifts, are questions of mere words, and it is needless to discuss. In my judgment, it would not be fair or right to compel her now to restore the money sought to be recovered by this appeal. So he's talking there, setting out there the principle that knowledge can be deemed if there is a failure to inquire into rights based on facts which are known. And secondly, that the principle applies not just in relation to equitable doctrines such as acquiescence, but also is applicable to cases of election or affirmation of contract. then Lord Justice Bowen, on page 192, comes to the same conclusion. It's about two-thirds down in the middle of the page. Was she aware of her rights at the time she formed this resolution? He says, it is enough if she was aware that she might have rights and deliberately determined not to inquire what they were or to act upon them. There again, I unhesitatingly draw the inference that she was aware that she had rights or might have them, and that she deliberately made up her mind not to enforce them.
That's not this case, is it? When the judge found that what his name is, Mr. Enser wasn't thinking about the question at all.
Well, my lord, the judge's finding, we say, is somewhat circular, because and is wrong, because it was founded on an assumption that there needs to be suspicion or knowledge of the right in the first place. We say that the facts that have to be known, or in relation to which the waiving party must be put on notice, are the facts, not that there's a possible right.
Well, doesn't that exactly the opposite of what's said by Lord Justice Bowen? It's enough if she was aware that she might have rights, deliberately determined not to inquire into them.
But my lord, as we'll see in some other authorities, whether the party might have rights is based objectively on the facts on which the party is aware. So in this case, we say Mr. Ensor knew he had a contract, knew there was an amalgamation. He knew that there were termination provisions, knew there was an amalgamation, and yet deliberately did not investigate what those rights specifically would be.
I think the judge found he didn't. He wasn't aware that he might have rights.
Well, but the judge found that he didn't understand what his rights were. Therefore, he could not suspect that he had a right, and therefore, obviously, available knowledge is not something that applies. We say that renders the extended definition of obviously available knowledge futile, because in order to have knowledge of the right, you have to, on the judge's reasoning, you have to understand it. So if you understand it, you know your right, and it's not necessary to therefore merely have a suspicion of what your right is.
But there may be an intermediate ground, or somewhere in the spectrum where you say, well, I think I might have a right, but I can't be bothered to look into it, or I'm deliberately not going to look into it because I don't want to find out the answer. Isn't that what Lord Justice Byrne is talking about here?
Well,
he says that she, as a matter of fact, she was aware that she might have a right, but deliberately decided not to do it, not to investigate it further. Whereas the judge here seems to have said, or did say, I think, that Mr. Enser was unaware that he might have a right.
yes, but she did that on the basis, she found that on the basis that he needed to have an understanding of what his rights were in the first place. And so there are two criticisms we have of that. Firstly, that's not the approach that's to be taken. I can take your lordships to some other authorities where it was the actual facts which give rise to the right that were the relevant facts, not just whether or not there might be a right. And secondly, as I've submitted, it renders, in the case of express terms, it renders the additional or extended definition of knowledge completely redundant, because you will never have obviously available knowledge unless you understand your right. And if you understand your right, you know it. So we say the answer must be that the party must be on notice of the facts give rise to the right, and it's the decision not to inquire into that which creates the knowledge. That I submit is clear from the judgment of Lord Justice Lindley at page 188, because there he's talking about an invitation on the facts to inquire into what the rights were. This form of knowledge was also addressed in the judgment of Miss Justice Manson, ICCI and Royal Hotel. Your Lordships have that behind tab 17, so that's volume 1 of the authorities bundle. At page 492. And he deals with the requirement of knowledge on the right-hand column. He says that what's required for affirmation is knowledge. And then over the page, at page 162, internal left-hand column, he deals with what he calls a special problem, where a person has deliberately and knowingly decided not to investigate a matter about which he knows he could acquire definite knowledge. Now, the matters of which, or on which the party in this case, the insurer, was on notice of, were fabricated charges, which had been fabricated for the purposes of claiming under an insurance policy. And we can see where he refers to that at page 170 in internal, page 501 in the authorities bundle. And it's the left-hand column. The first third of that column. And Mr. Justice Mance there doesn't talk about having to have knowledge of the rights or a suspicion of the rights. He's simply focusing on the consolidated charges, the fabricated charges. Then in another case, that of SK Shipping Europe versus Capital VLCC, which your Lordships have in the authorities bundle volume 2 behind tab 34. This was a decision in relation which concerned misrepresentations as to fuel consumption of vessels which have been chartered, VLCCs.
Sorry, what tab number did you say?
This is tab 34, my lord.
Don't think it is. 33.
I beg your pardon.
That's fine.
SK Shipping.
SK Shipping, yes, that's right, my lord. So the court was concerned with consumption of vessels, VLCCs, which had been misdescribed in the documents. The judge, Mr. Justice Foxon, held that where there are facts of which a party is aware, namely the consumption figures as stated being incorrect, then that's what gives rise to the obviously available knowledge.
I'm so sorry. Did you give us a reference for that?
Well, I'm just about to.
I'm so sorry. Yeah.
So that he dealt with that in. I was just summarising the point, my lord, but we can see that in paragraphs 212 to 215 of the judgment, which your lordships have page 1069, 899 internal. So he deals with the defendant's knowledge of B on 899. And again, and at 213, showing they considered the position in relation to the consumption figures. Again, he doesn't in the judgment say that what the chargers had to be on notice of was their right. They had to have knowledge or a suspicion of what rights they had.
Isn't this a case where they, no doubt they knew what their rights were? The question was what the facts were, what facts they knew about.
Well, it was a case of misrepresentation. So rescinding from misrepresentation as opposed to express contractual rights. So the point that was being made was that there was sufficient knowledge of the facts triggering the right. There was no consideration of needing to know whether or not there was a right to terminate or rescind at common law because of misrepresentation. And it's going back to what Mr. Justice Mance, as he was then, said in ICCI and Royal Hotel, it's a matter which a party could find knowledge of. It's not limited to the legal rights which need to be investigated. It's the matter which needs to be investigated. Now, applying that to this case, we say that Mr. Ensor, he knew he knew his company had termination rights. He knew that those termination rights referred in some way to amalgamation. He knew there'd been an amalgamation, but he deliberately decided not to take any step to investigate what URE's rights would be. And as the judge found, that was because he was focusing, not unsurprisingly, he was focusing on the long-term contract.
Are you saying that the judge found that he deliberately decided not to investigate? Are you saying that's a finding the judge made?
No, the judge didn't find that because she found that there was no deliberate decision not to investigate because Mr. Ensor simply had no idea what his company's rights were. But she did find that he and URE were focusing on obtaining the long-term contract. Now we say that because the judge found that commercial priority of URE was to continue the contract and seek to obtain the long-term contract, that must have involved a deliberate decision to simply continue the contract and not inquire into what termination rights may or may not be applicable.
That goes quite a long way beyond what the judge actually said.
Well, she found as a fact that URE was focusing on the long-term contract, which is why it was not considering termination at all. Find the reference for your lordship.
I think it's paragraph 144.
Well, yes, there was another. I'll come back to it, but there was another reference in the judgment to focusing on the long-term contract. Yes, it's paragraph 121, and in particular, bottom page 174. The last 4 lines on page 174, and over the page, first 3 lines. So, as a matter of fact, she found that URE's entire focus really was on obtaining the long-term contract, and in those circumstances, they weren't even contemplating termination. My lords, another reason why there is no hard and fast rule of actual knowledge is, of course, there is.
So just before you say that, what's the point you actually get from the C Challenger case?
From which case, my lord?
C Challenge or SK Shipping?
SK Shipping.
The
point is, well, the point in both ICCI Royal Hotel and SK Shipping is that it is the facts giving rise to the right of which the waiving party has to be aware, coupled with a deliberate decision not to investigate what its rights are, which satisfies the extended definition of obviously available knowledge.
What does that mean? You know the facts, and there must be a deliberate decision not to investigate. How can you reach? What do you mean by deliberate? If you just don't think about it, because you don't know you have rights, and don't suspect you have rights. In what circumstances can there be a deliberate decision not to do something?
Well, you know of facts which reasonably would lead you to conclude that there are potentially some rights, but you decide not to take any opportunity to investigate what those rights might be.
Which you appreciate lead to the possibility you may have rights. Is that not a central part of that formulation?
Lord, no, because I mean, on the facts of this case, knowledge of the rights, or not knowledge of the contract, is established. Obviously, wasn't denied, and knowledge of the termination clause is established. Mr. Ensor said he knew and he knows of the amalgamation, irrespective of whether or not he knows he has any, URE knows it has any rights at that stage, deciding not to investigate whether it has any rights at all, not to confirm.
When was that decision made here? Where's the evidence as to Mr. Renton making a decision that he would not investigate?
Well, there's no express finding to that effect, but I say the effect of the factual findings made by the judge that URE was simply focusing on the long-term contract and was not even thinking about termination means that it took a deliberate decision to pursue a higher commercial priority rather than terminate the contract or even look into what its termination rights were. My Lord, there's another example of knowledge which is not actual, but which is deemed or presumed, and that of course, in relation to parties who have the benefit of legal advice. That is dealt with in the authorities as an evidential burden, and we've referred in our skeleton to the decision of Mr. Justice Leggett as he was in Volnert, which your lordships have at in the authorities behind tab 27, page 805. And it's paragraphs 159, 160. Well, really, paragraph 160. That's where he says there's a presumption because it mitigates the inherent unfairness in having to show that there's knowledge of a legal right, which the other party would find very difficult to establish.
But that's different from the principle you're contending for, isn't it? Because that's a rebuttable presumption which applies across the board to all kinds of different rights. Whereas what you're really contending for is deeming in a way which is not rebuttable in the case of contractual rights.
That's right, but it is different, my lord, but it goes to the wider principle that there are other forms of knowledge other than actual knowledge which suffice for purposes of principle of election. So if a party decides not to waive privilege, which in more complicated cases one can see that might well be the case. But if a party decides not to waive privilege over its file, solicitor's file, it is presumed to know of its rights, even though it might not actually have knowledge of them.
This isn't, though, saying that there's something other than knowledge. It's saying this is how you go about proving knowledge.
Well, yes.
It's not an exception, in fact, to the rule that knowledge is required. It's
Lord, no.
about how you go about proving.
Lord, yes, and it comes back to the point we had in exchanges with Lord Justice Zacaroli that we're not saying that there is no requirement for knowledge. It's all about how knowledge is established. It can be deemed, it can be attributed because of the express terms of the contract. It can just be assumed as a matter of statute. But there is still knowledge there, it's just how you get to it. Then the final permutation, as it were, of the principle is a fluxion of time. As we saw from the judgment of Lord Gough in the Kashin-Junga and in Lord Justice Rick's judgment in Cosmar Villa, that even if no election is made, the law steps in after a certain period of time and takes the choice away from the party and holds it to have made an election. Now, that is another form of deemed knowledge because the law deems an election to have been made. And an election can only be made if there is knowledge. So even if there is no actual knowledge that gives rise to an informed choice, and even if no choice is taken, if after a certain period of time it's right and just for the law to deem an election to have been made, then that's what the law will do. And as Lord Justice Rick said in Cosmar Villa, that is the response, pragmatic response of a principle which is aimed at ensuring that the parties need to know where they stand. So, for example, in this case, if the parties had entered into the long-term contract, which was for 25 years, if there had been an amalgamation in year one, and URE continued with the contract for another 20 years, then URE could not say, well, they didn't make an election because they didn't know what their rights were. After 20 years, it must be right that URE would have been deemed to have waived its right to terminate. That in circumstances where the parties would have continued with the contract for 20 years, and it simply can't be a fair and common sense outcome for parties to then 20 years later be able to rely upon their own ignorance of their express contractual rights to terminate a contract and claim a termination payment.
Doesn't Lord Gough say in that passage that knowledge is required for all forms of election, including by a fraction of time? I accept that he leaves to one side the nature of the knowledge, but I think in the passage you showed us, in the right-hand column, it says, whatever the basis for saying there's been waiver, knowledge is a requirement.
Well, he says generally. So if your Lordship were to go to Authorities Bundle, page 373,
tab 15.
Well, first of all, page 398. Of the judgment on the left-hand column, just to go back to the point we looked at earlier, my Lord, about 2/3 of the way down, he says in all cases he has in the end to make his election, because if he does not, the time may come when the law takes the decision out of his hands. Now, just pausing there, that is in my submission, a long stop of the requirement of knowledge, because he's there saying that the principle operates that after a period of time, irrespective of whether you have knowledge, the law steps in and holds that effectively you did have knowledge and you made your choice.
Yeah.
Then on the right-hand column, he says generally it's prerequisite to have knowledge of the facts. And then goes on to say, in parenthesis, he's not considering cases dealing with knowledge of the right.
Yeah. But he's saying generally knowledge, whatever the requirement of knowledge is required for an election.
Yes, generally, but if you have a period of time which has expired, then the law calls time on that and effectively deems you to have made an election. And that's the same with the same reasoning I submit applies in relation to Cosmar Villa at paragraph 74. which is page 689. It's volume 2, tab 23, page 689. So there, we looked at this earlier, but there, Lord Justice Ricks talks about the requirements of making an informed choice, and then goes on to say at H, however, there will be some circumstances where even if there's no election, parties regarded as having exercised after a reasonable time has passed, and he refers to Lord Gough and the Kanchenjunga.
Yeah, and again, he refers to knowledge being a requirement. So it's time passing after what he calls the relevant knowledge has arisen.
Yes.
So that doesn't seem, sorry to labour this, but that doesn't seem to be saying that the effluxion of time is as it were an alternative to knowledge. He seems to be saying where knowledge has arisen and enough time has passed, the person may be taken to have elected. It doesn't seem to be quite saying what I think you were suggesting, which is that the effluxion of time is a way of satisfying the requirement of knowledge. That seems to me to be a different proposition.
Well, Lord, what I submit he's saying there is that when he refers to the choice created by the relevant knowledge, what he's saying there is that if you have the knowledge, so you have the choice, then but if you don't have the knowledge, you don't have the choice, and even in those circumstances, the court steps in and says you're regarded as having made an election. As I submit, applying that to a hypothetical case where there would be an effluxion of, say, 10 years out of a 15-year contract, my submission is that the principle of election would hold the party to have made its choice, because, as Lord Justice Ricks says, that is part of the rationale of a doctrine which seeks to give a pragmatic response to parties in contractual relations who need to know where they stand. So if it's right that the law can step in when no choice has been made, and the whole decision-making process is taken away, then that decision-making process is taken away even if there is no knowledge. Lord, I'm conscious of the time. I want to now just address certain aspects of the various grounds. I've spent a lot of my time on the authorities.
Yes.
We've covered a lot of territory also, obviously, in the skeleton arguments, and I will deal with any other points in reply on those points of law. But in relation to ground 1A, which is that the judge wrongly concluded that for purposes of waiver, URE should not be taken to know of the express terms. I think your lordships have my submission on that, because clause 10.2d expressly set out the termination right in the contract. We say, in light of the authorities, that the URE is deemed to know what its rights are or were. And that had the judge applied the correct test, merely of knowledge, which URE admitted it knew the term that existed, had the judge applied the correct test of knowledge, then she immediately had the answer to the question.
Yes.
And we say that the judge's reasoning contradicts the principles which we derive from Payman and from Sargent, which is that there's a distinction to be made in relation to express contractual terms. Lord, in relation to the
Was the
procedural...
judge taken to the Australian cases?
Lord, no. Lord, no. But obviously the judge was taken to Payman Lanjani, which referred to case of the state, but
Yes.
no, she was not taken to the Australian cases.
Okay.
Lords, in relation to, as I outlined in my introduction, in relation to ground 1A, there are certain procedural objections to it. I don't know whether your lordships want to hear from me now on those, or whether you want to hear me in reply to my learned friend.
Well, you've only got about half an hour left, so maybe better to defer that.
Yes. Yes, then ground 1B, which follows on from ground 1A, where we say that the judge wrongly held that it was necessary for URE to understand clause 10.2d. And we say that the judge took into account matters that were irrelevant for the purposes of establishing knowledge of the right. For example, she referred to the fact that the contract was negotiated at speed. That's in judgment paragraph 104. She held that Mr. Ensor only skim-read the clauses. She held that he focused on some but not other clauses. And she held that he assumed that the clause was dealing with insolvency matters only and not a solvent amalgamation. So in effect, what the judge found was that the URE did not have knowledge of the right, not because it didn't have knowledge, but because it didn't have understanding of what the clause meant.
What's the difference? If I know there's a clause in a contract, don't understand it to give me a right, therefore I don't know that I have a right. Doesn't that follow?
Well, the test is whether you know you have the right, and you know the clause is there. You're therefore taken to be bound by.
Well, that's 1A, isn't it?
Well, you're taken to be bound by whatever objective interpretation the court may give to it.
And that's your 1A point, your ground 1A.
Well, ground 1A is that you know it because you're taken to know it because it's in your contract.
Yes.
Ground 1B is that you that there's no test of understanding because you know you have the right, and Mr. Ensor said, I know I have the term there, but applying a test of understanding is not a test that's been referred to at all in any of the authorities. And I understand the logical argument which URE advances and your lordship puts to me, but there is knowledge of the express term giving rise to the right, and therefore URE is taken to be bound by whatever interpretation the court would give it. It doesn't. I mean, logically, the argument is put in relation to express terms of the contract. It doesn't necessarily have to just apply to express terms. If it was a common law right to rescind for fraudulent misrepresentation, the waiving party could say, or would say, well, I'm aware that there is potential to terminate a contract for if someone has lied to me and induced me into a contract, but I just don't understand how it works. I don't understand how it operates or how it applies in these circumstances. In my submission, applying a test of understanding in those circumstances or in that way, is requiring there to be knowledge of consequences of the right. If there is knowledge of the express term, that satisfies knowledge. Having to have an understanding, a subjective and precise understanding as to how it operates and how it applies in particular circumstances, is effectively a test of knowledge of the consequences of having the right.
Is that a convenient moment?
My lords, yes.
Very good. 2 o'clock.